Good afternoon and welcome everyone. So welcome from the Legal 500. I'm James Wood, one of the editors at the Legal 500, and welcome to this afternoon's webinar, Preparing for Disputes in an Economic Downturn with Herbert Smith Freehills. Before I introduce Craig Shepherd of Herbert Smith Freehills, just want to say a huge thank you to the two GCs who will be joining us today. So obviously with anything like disputes, it's always interesting to get the perspective of business, and I'm pleased to say we have Hajime Seki of Amgen and Kenji Tagaya of JERA, so life sciences and energy sector respectively. So thank you both to them, really do appreciate it. And thanks to all of you in the audience. Good to have GCs watching this, and hopefully you'll ask a lot of questions. So if you do have any questions throughout the session, please use the Q&A function. We want to hear from you. We'll get around to them at some point in the proceedings. That's all for me. I'm going to turn over now to Craig Shepherd. Craig, welcome.
James, thank you very much. Well, welcome everyone to what I hope will be a lively and fun discussion. Let me begin by introducing myself. My name is Craig Shepherd. I'm a partner in our Tokyo office. I'm the head of our global construction disputes practice. I'm based in Tokyo now, but before this I was in the Middle East, and before that I was in Hong Kong. I'm going to be acting as chairman and posing questions to the other panelists. So hopefully you will hear very, very little more from me and an awful lot more from them. We've got 5 panelists. I've got 3 of my colleagues and 2 guests. So James has briefly introduced the guests, but let me say a word about each of them and ask them to identify themselves. So let me start with Kenji Tagaya. Tagaya-san is the General Counsel, Chief Executive Officer and Head of the Legal Group at JERA. As I think many of you will know, JERA is Japan's biggest generator. It is, I think, generates a third of Japan's electricity, and so is no doubt powering much of the Zoom that's going on at the moment. And we have Hajime Seki. Seki-san is Corporate Officer and Head of Legal at Amgen. As James said, he's in the life science biotechnology industry. And I have promised that if anyone posts a question to say, what is the cure for COVID-19, we will not actually ask Seki-san to answer that question. From Herbert Smith Freehills, we have David Gilmore. David is, again, a partner in our disputes team in Tokyo. David is actually the managing partner of the Tokyo office and has been here for 16 or so years. So we will draw upon him for a sort of background and the history of disputes in Tokyo. Rather younger, we have James Alsop. James is an of counsel in our disputes team, again based in Tokyo. And Yosuke Homa. Yosuke is a senior associate in the disputes team here. That was really all I wanted to say by way of introduction. But let me begin with sticking the first question to my managing partner, which I think is the way I have to begin these things. David, COVID is clearly unprecedented. There's never been anything quite like COVID in the past. But there have been lots of previous global incidents and global uncertainties and upsets, the financial crisis being an obvious example. You've been in the Japanese market for a long time. As people look to reevaluate and reassess deals and investments and acquisitions, do you see any real implications on the dispute side for the business that those dialed in are engaged in? And perhaps start by focusing on the pretty fundamental sector of M&A and investment activity.
Okay, thank you, Craig. Hopefully I've managed to take the mute off. Thank you for that. The first thing to acknowledge, as you've done there, is that the economic situation at the moment is, of course, it's unprecedented in itself. It's fast moving and it's not monolithic in that it's hitting some sectors more than others. And the recovery of businesses and the value of those businesses will be faster in some areas than others. But as you say, look, there's a general proposition, isn't there, that it seems safe to conclude that there will be a lot of recent acquirers of businesses who will have bought effectively at the top of the market, some of whom may now be looking at what their options are in terms of maybe getting out of the deal if they can, or otherwise improving their balance sheet position. So with that in mind, I think we will see increased disputes, increased claims in the mergers and acquisitions context over the next cycle. And I think that will come through in two phases, the first more immediate than the second. So if we start with the first phase, I think this is going to be readily on us. And this is going to be where buyers are looking to get out of deals after the execution of the sales contracts, so the SPAs, the sale and purchase agreements, but before completion of that deal. And that's because of what we've seen in terms of a practice emerging recently of increased use, being increasingly common for there to be a gap between execution and completion. And for that gap to be getting longer and longer, perhaps as long as 6 months, is now not untypical between the signing of the sale and purchase agreement and then the eventual completion of the deal, including payment. And all these have created that gap for the purposes of providing for a number of condition precedents that then have to be satisfied in that period in order for the deal to complete. Now, condition precedents can range from not very controversial things at all, such as where it's necessary to get regulator clearance for a deal. That can be a condition precedent, and that's not very controversial. So hopefully this will be obvious to everyone, but to be clear, a condition precedent is an event which has to be achieved in order for the buyer to then become absolutely obliged to complete the purchase and to hand over the money to the seller. And in the past few years, as I've mentioned, we've already seen a creeping tendency to add more condition precedents. Some of them have been drafted in such a way as to potentially reduce the pressure on buyers to complete. So for example, instead of having an absolute obligation to pay the purchase price, it might instead be that the completion is made subject to the buyer being able to source financing, or perhaps even better still for the buyer to source financing on terms reasonably acceptable to them. So it should be obvious that the more condition precedents you have, the more subjective they are, they're more under the control of the buyer in terms of their performance, then the more they're going to give the buyers the ability, if they wish, to frustrate and delay the deal, and therefore it's more likely we're going to see disputes emerge. I should just add that, look, very similar issues can arise where the parties have agreed a material adverse change clause in their sale and purchase agreement. Depending on the definition of that clause, it might allow the buyer to try to call off the deal between signing and completion, depending what's in that clause, for similar sorts of reasons. So I think it stands to reason that these sorts of disputes are going to be seen during or shortly after the expiry of these periods for completion of the condition precedents. So that points to probably an increase in these types of problems in the third and fourth quarter of 2020, if not already. And to be fair, we've seen an increased number of these types of disputes in recent years anyway. And that will be fed by the tendency we've seen to include more condition precedents and more subjective ones, but the economic downturn will act, I think, as an accelerant, given the extra motivation of some buyers to re-examine the deals they were previously committed to. And then if you were listening at the start of my long answer, there's a second phase coming. I think this will start probably more likely in 2021 and continue for the next year or two. And that's going to be where disappointed buyers who have bought again at the top of the market will be busily reviewing the representations and warranties made by sellers in the sale and purchase agreement. So these can be the typical financial representations and warranties going to the accuracy of the financial data supplied to the purchaser at the due diligence stage, or for example, to compliance with law and anti-bribery legislation by the selling company, and so on. But if buyers really find a sniff of a breach, then many will have very powerful motivations to use those agreements, those clauses, to bring claims for financial loss, against the seller, or even perhaps depending on the terms to try to reverse out of the acquisition at all. So that was rather a long answer than perhaps I intended, but the short answer is yes, I think we will see a cycle building from the end of this year over the next 2 or 3 of increased disputes coming out of recent mergers and acquisitions.
Well, then, just to follow up on that, but keeping this one brief. Obviously, your clients, I'm sure, wouldn't dream of abusing conditions precedent, but assuming that someone less scrupulous than your client does, is there much that the seller can do to protect themselves?
It's one of those where prevention is better than the cure, of course. So as a seller, don't accept going forward a long list of condition precedents, or at least push back hard in the negotiations. And certainly do all you can to avoid those which give the seller some discretion as to whether those condition precedents are going to be achieved or not. So an example of that latter one would be a condition precedent that the buyer isn't obliged to complete the sale until he's obtained finance, or even obtained finance on terms reasonably acceptable to the buyer. That's really a classic example that loads the dice in the buyer's favor and gives him the ability to play those games. And then if you're forced to accept those, or you've recently concluded deals and you've got similar provisions in them, and then you are on the receiving end as a seller or a buyer who's now wriggling to get out of a deal based on this, then clearly you need to maintain pressure on the buyer where you can, help them achieve the condition precedent in question. Push them and don't accept delays. If the periods get extended, make sure those extensions are short. We've even seen clients commence proceedings in arbitration or otherwise in order to compel buyers to get on with achieving those condition precedents, and often that's been quite an effective next step.
Moving away from the world of M&A and into continuing I think of the world of power as involving many companies, people who are supplying things, people who are contributing things. I suspect that you look at more contracts than most of us ever see or would ever want to see. Have you been inundated with people claiming force majeure, for example, in relation to the incidents and trying to delay performance? Is force majeure something that you yourself have been needing to rely upon?
Well, thank you, Craig, and thank you for the introduction. I am Kenji Tagaya, representing maybe in today's panelist composition, I am representing energy sector. So I will speak from the energy players perspective. So my firm, JERA, is not only a power generation company, but also we deal with fuels such as gas, and we also engage in renewables energy sector. So throughout the energy supply chain, we've seen huge amount of potential disputes. The first thing we observed at the initial stage of COVID-19 was maybe back in February, when energy demand basically disappeared all over the world, because many countries stopped economic activities, factories are shut down, people stopped, commuting. So what happened first was basically the huge decrease of energy demand, but companies like ourselves are not working on such a flexible basis. Usually our fuel procurement contract is a 20-year long contract, and therefore we cannot stop receiving the cargoes of gas and liquefied natural gas. Therefore, what we saw in the industry was so many players started claiming force majeure, claiming that basically their demand disappeared, and therefore they cannot receive. JERA is a kind of middle company, so we sometimes buy, but at some occasions we also sell. So in both situations, we were in such a difficult positions. People started claiming force majeure, but we also studied whether it is okay to claim force majeure. But it turned out that the industry wisdom was it's not so straightforward. The mere disappearance of demand is not kind of force majeure. So in some limited circumstances, such as the port was locked down, the entire town was locked down, and as a result, there is no receiving terminal operating, then maybe worth exploring the possibilities of force majeure. But I think come to this common understanding itself took about two months or so, such a chaotic situation. And suddenly then afterwards, maybe in April or May, demand has started to come back in some countries. So energy companies like ourselves had to scramble once again to procure necessary energy supply, energy fuels to cope with the increase or sudden increase. So I think not only force majeure, but also throughout the energy supply chain, so many potential disputes were claimed. And I think energy players like ourselves are still discussing whether it has some grounds to claim force majeure. And careful study was needed throughout the process.
Thank you, Tagaya-san. James, Tagaya-san has identified that force majeure perhaps isn't the magic bullet that is going to give you the answer every time. Are there other things that you've been advising on apart from just force majeure?
Thanks, Craig. I think what we're seeing is that in addition to parties looking to delay performance, in circumstances where contracts have become uneconomic or undesirable due to changes resulting from the pandemic, often parties are looking to limit their losses by just exiting contracts altogether, and looking to see whether there are ways that they may be able to terminate. Now, there are a number of ways that can typically be done, but generally it'll start with a close examination of the termination provisions in the contract in question. And most contracts will contain express termination provisions. Now, it's unlikely that there would have been something catering specifically for the declaration of a pandemic by the World Health Organization. But it's not unknown for parties to have been able to negotiate walk-away rights, where they can exit on notice but without cause. Alternatively, we've seen parties looking very closely at whether any delay or impact on the performance by their counterparty might be sufficient to trigger the right to terminate for material breach, for example. There's often not an easy answer to these questions. It'll depend on a sort of quite a close examination of the factual circumstances and also interpretation of the clauses in play. But when the economics of a bargain have changed as dramatically as we're seeing here, parties can be very creative in an effort to try and rely on a termination provision. I think an area that we're likely to see a real focus on, already have done and will continue to do so, is counterparty solvency. It's quite common for there to be termination rights which are triggered by defined insolvency events. And as companies come under severe economic pressure, there's a real risk that they might trigger them. A word of warning, though, that we've seen some countries have been legislating to try and curtail a sort of a broad sweep of contracts being terminated as a result of the fallout from the pandemic. And the UK is a good example. It recently brought into effect the Corporate Insolvency and Governance Act, which has sought to put a temporary restriction on the ability of parties to terminate for insolvency where the insolvency is related to or caused by the pandemic. So it may not be as easy as you would expect to be able to terminate based on counterparty solvency. I suppose a related point is that if solvency is becoming an issue, so it follows that people will be looking ever more closely and thinking more carefully about the adequacy of security that they might have in place. Again, though, it's not just whether the security is adequate now that you need to be worrying about, but also whether it's enforceable. So, for example, the act that I just mentioned in the UK has also placed restrictions on the abilities of parties to enforce security in the current circumstances, requiring that court orders be obtained. So I think termination is a big issue, certainly arising out of the contracts. And the only other point I'd make is that parties also need to be alive to termination rights that arise not from the contract, but from the underlying law itself, and in particular need to be alive with how those legal termination rights might interact with provisions in the contract. So, for example, under English law, in circumstances where there's been a breach of a condition or a party has evidenced an intention not to perform a contract, there may be a right to terminate on the basis of repudiatory breach. But interestingly, a party may be able to terminate for repudiatory breach, even in circumstances where that's been caused by a force majeure event. So whilst you may be able to claim force majeure to avoid a claim in damages, that force majeure protection wouldn't necessarily protect you from your counterparty nevertheless being able to terminate. So I think a number of potential pressure points.
Okay, thank you, James. Seki-san, can I come to you, please? We've heard James has talked through some of the pressure points which exist. Tagaya-san has explained the complete collapse there was in demand that he saw. I suspect, and I'm guessing here, but I suspect in the industry you're in, you've seen a different change from a collapse. The world of biomedical supplies must have been turned on its head. I'd be very interested to hear what steps you've been taking and what you have been doing.
Yeah, sure. Thank you, Craig. And yeah, as you can imagine, yeah, we get a very strong sense of urgency when we realized that situation was getting more serious and more serious. And I think back into in February of this year, first things I did was that right after I realized the situation getting a bit worse and worse, I circulated sort of the legal alert for all business leaders to flag potential legal issue or dispute that might occur in connection with the pandemic. And so then my team revisited and updated all contract templates, specifically by inserting our COVID-19 to force majeure events and termination events. So then thirdly, this is very specific, but we also negotiated on some specific contract to insert additional clauses so that we can have some flexibility as things were evolving. So actually, there are some cases that would potentially be escalated to actual dispute, but fortunately, as of today, we haven't had any such case.
Seki-san, you said that you were looking to negotiate provisions to give you flexibility. But without going into details of who you were speaking to, I would be interested to know the reaction that you got when you tried to negotiate such provisions. Were contractual counterparties generally willing to discuss and willing to negotiate, or were you told, get lost?
Yeah, thank you, Greg. And it's very interesting, but unfortunately, we haven't had any harsh or strong reaction from the contract counterparty. So they are basically very natural and very reasonable to sit down to discuss because they fully understand the situation. So, right, and they also have the same or similar situation. So that's why negotiation was basically going well.
Okay, thank you, thank you. Yosuke, I'm going to come to you now, but David, James, let me give you a bit of forewarning so you can put your thinking caps on. We've got a question from the floor about whether we can argue that acts of government intervention give us a ground to terminate for force majeure if a government looks insolvency. I'll ask one of the two of you to be brave enough to pick that one up in just a moment. But Yosuke, let me come to you. We've just been talking about force majeure events and how that works and what the issues are from COVID-19 first wave, COVID-19 first time round. The press is full of coverage of the possibility of a second wave. Does the position remain the same, or is there anything we need to be thinking of?
Thanks very much, Craig. Now, I think it's important to just go through at high level the force majeure position under English law. So it typically allows you to temporarily suspend the duty to perform contractual obligations in circumstances where you're prevented from performing the obligations as a result of an unseeable event or circumstance beyond your control. Now, the precise test will depend on the wording of the contract, obviously, but turning back to your question of the second wave situation, you still have to consider the same factors when determining if there's a force majeure in the second wave instance. And the important point here is to note that the factual circumstances would be different in the second wave. So it may lead to a different answer compared to the initial onset of the pandemic and the restrictions that were placed at the time of the initial pandemic. So, we're all aware that the COVID pandemic is in existence, and there's a lot of discussion about the likelihood of a second wave. So it's arguable that now it's foreseeable that the second wave will happen, and it may adversely impact on your ability to perform your contractual obligations. Now, this can be problematic, especially if he could reasonably be expected to take precautionary actions in the period between the lifting of the initial restrictions and the implementation of any restrictions after the second wave. And if those actions or efforts should have allowed you to continue to perform your contractual obligations when the second wave hit, but you failed to put those actions in play, then there's a scope for argument about whether or not your inability to perform the contract obligations was actually caused by the second wave restrictions or your failure to take those actions yourself. So, so you may still be contractually liable to the counterparty. So, what steps you reasonably might be required to take would be highly dependent on the circumstances that you find yourself in. Another point to look out for is that you're often under an obligation to mitigate the impact of a force majeure event. So in a second wave scenario, you might think that you simply need to take the same measures that you took for the first wave. But given this is the second wave, the same measures may not be sufficient. It might be expected, for example, that you might be able to implement those mitigation measures much quicker, or that the mitigation measures that you should implement might be different depending on the restrictions that are put in place for the second wave. Now, looking at sort of the parties who might be looking to enter into new contracts at the moment, there's a risk that you won't be able to invoke any force majeure provision if you're prevented from performing those obligations now, because the COVID-19 pandemic is foreseeable, and therefore invoking force majeure may be challenging. So in those circumstances, when you're looking at new contracts, we'd strongly recommend that you have a specific provision in relation to any risks associated with the COVID pandemic, if you anticipate that these types of restrictions around COVID might impact on your contractual performance. Alternatively, if the counterparty has been difficult, then you may look at insurance to protect against any foreseeable risk in this respect.
Thank you. Thank you, Yosuke. David, James, was either of you feeling that you wanted to have a crack at the question of the implications where the government blocks insolvency due to coronavirus? What arguments might be available?
Looks like I've blinked first, so I'll have a go. I mean, I think at the risk of giving a sort of horrible lawyer's answer, when it comes to force majeure, the devil is of course in the detail, and everything will turn on the specifics of the clause in question. Now, it's not uncommon to see reference to acts of government in force majeure clauses, along with things like acts of God. So if you're in circumstances where you have that reference in your clause, that's a good starting point. Whether it will be sufficient will, of course, depend on exactly what it is you say the government has done. So in circumstances where legislation has been passed, there's been an enactment of a law, I think you would be on better footing than in circumstances where there have been recommendations that have been issued, which may nevertheless have had an impact, but were not strictly binding. Now, I suppose ultimately it will then come down to, can you demonstrate that you satisfy the requisite tests which Yosuke has outlined already, and in particular that whatever you say that force majeure event was has caused your inability to perform. And certainly if you're talking about termination for force majeure, that it is going to have a continuing impact on your ability to perform for sufficient duration that you should be entitled to terminate. And equally, and perhaps more challengingly, that there were no reasonable steps that you could have taken in order to avoid or mitigate the consequences of that government action, which is often a challenging point and one of the most debated points. So I suppose my answer is it's certainly conceivable that it could be arguable and potentially well arguable, depending on your contract, but unlikely to be straightforward, I think is the answer I would give.
I guess you're raising the theological question that we can't possibly answer in this session of the extent to which a deadly outbreak can be the act of a benevolent God. That's one for answers on a postcard, I think, later on. David, given that James fielded the last one, let me come to you. There's lots in the press about the extent of the economic disruption. I think everyone is predicting that the world's economy is being turned on its head. All sorts of contracts are going to be distressed and impacted. Can the dispute system cope? Do we have the judges, the arbitrators, the systems in place?
Well, I guess we'll find out. As you say, it's two things combining, isn't it? The challenge is increased demand, as we anticipate for dispute resolution processes, and like the rest of us, reduced ability to deliver what would be a normal service, given travel restrictions and everything else we're all facing. But if we start with the assumption that the two principal forms of dispute resolution in international business is court litigation on one hand and international arbitration on the other hand, then I think we're likely to see that international arbitration is probably, in the main, better placed to deal with what's going on and to suffer less significant delays as a result. And that's for probably many reasons, but a couple of principal reasons. The first one is there's inherently more capacity, I think, within international arbitration, partly because the pool of potential arbitrators is vast. And in a sense, it's not finite, because depending on the arbitral institution you're using, you can usually or often appoint arbitrators without reference to any limiting panel of arbitrators. So there's a lot more capacity there. In contrast, courts, of course, have finite capacity. They have limited judges and limited infrastructure. Many systems were in fact already struggling with pretty horrific delays before COVID anyway. And then secondly, it's related, but it's a different point. International arbitration is just inherently a more flexible form of dispute resolution in terms of process and processes. I think it's fair to say that we've seen arbitration institutions and arbitration panels trying to get on the front foot in 2020 and trying to embrace the new normal as it emerged and evolved, and making flexible arrangements for online evidential hearings and the like. Now, courts will make progress too, but probably will lag some way behind. That said, it's important to recognize that not all court systems are the same. Some will cope better than others, but those that suffered with pretty bad backlogs already will probably be in the least best place to cope.
Seki-san, David has just given us the pro-arbitral position, if I can put it that way. Explained that arbitration is very flexible and has a sort of infinite resource. But before we came on air, you were telling me of some rather impressive success you've had in the court system coming into COVID-19. Do you want to share that with everyone else? I think you're still on mute.
Sorry, can you hear me?
Yes.
Okay. Yeah, it's actually a big case for our company, but it's a part of the global patent dispute with a multinational pharmaceutical company. So what happened was that at the end of the April, just before Golden Week, right? Everybody was looking forward to being able to be relaxed. But our Supreme Court of Japan upheld our case and granted in Amgen favor permanent injunction against the counterparty's brand name drug in Japan. So to be honest with you, timing-wise, it was not expected, because almost all court proceedings were suspended under the emergency declaration. But we were mobilized based upon the strategy and the plans we created last year in anticipation of the potential court decision to grant a permanent injunction for our company, which included, of course, the plan to meet product demand increase as a result of the counterparties withdrawal from the market. So also during the COVID-19 pandemic, we needed to communicate and engage by all available virtual means, including Skype, WebEx, and telephone. So with various stakeholders, including regulatory authorities, patients, customers, and the media to handle and manage the various reaction from each of them with respect to the already approved drug being withdrawn from the market. And also we have to ensure accurate and full understanding of the how Amgen was taking thoughtful and conscious steps to care existing patient of the counterparties approved drug. So yeah, that's very specific for our company, but and also a big case, and fortunately we managed to almost everything as planned.
Well, congratulations. There weren't too many decisions coming out during the lockdown period. To get one from the Supreme Court is particularly good, and to get a winning one is even better. Tagaya-san, Seki-san has mentioned, I noted down Skype and WebEx and various other things. And obviously we're doing this event now by Zoom. Is technology the answer for how we're all going to be doing disputes from now on?
Yeah, definitely. I think we also experienced the usage of technologies in conventional type of dispute resolution without entering into the confidential details. We have a couple of live arbitration cases outside of Japan, and the cases are continuing. So we sometimes have to contact the arbitrators. We have to agree to the schedule going forward, that kind of thing. So just a brief comment from the practical users perspective. You know, although arbitration institutions advertise that technology is available, you know, virtual hearings are okay, but you know, when it comes to live, you know, case handling, of course, arbitrators are usually like retired judges. Not all of them are tech savvy, so we had to explain why this process can be done. We had to agree between the parties in the first place whether this can be done through the internet. So I think the arbitration institutions explanation is one thing, and whether you can apply those modern ways to your live dispute cases is a kind of different matter. We sometimes had to convince the arbitrators, you know, maybe three arbitrators typically, and not all of them are fully aligned when it comes to the usage of those modern technologies.
James, have you found great success in convincing arbitrators to use the modern technologies to pick up on Tagaya-san's phrase?
I think it's a very fair point that Tagaya-san makes. I think even before this context of trying to convince arbitrators to use virtual hearings, we've had a lot of fun and games, even with the hopefully more simple task of just using electronic bundles. I think actually I've probably had some experience on the other side of this question. So not in terms of being able to persuade the arbitrator that it's appropriate to use a virtual hearing, but actually a situation where the parties themselves are unable to agree as to whether it's appropriate for a hearing to proceed virtually. So in a case I have going on at the moment in Vietnam, there was due to be a bifurcated hearing. The parties couldn't agree as to whether the first phase should be held virtually or not. It really obviously isn't practical at the moment for that to take place in person. So ultimately the consequence there was that the proceedings will no longer be bifurcated and everything will be held at one hearing, unlikely to be heard, I would have thought, until the middle or possibly the latter part of next year. So I think Tagaya-san is absolutely right that one issue with the viability of virtual hearings is the sort of appetite for the arbitrators, but another is the appetite for the parties. And in that respect, I think it'll be interesting to see whether the increased use of virtual hearings, which we undoubtedly have now. I read a statistic the other day that the HKIC has held, I think, 85% of hearings over the last couple of months virtually. So it's happening. But whether it stands the test of time, if it is just a solution that we're having to use now, or whether it heralds a broader change, I'll have to say for my part, I think whilst we might get there one day, as and when things return to normal or something approximating normal, so we will see parties reverting back to wanting to have in-person hearings where they can.
Very quickly, not to divert us, but James, bifurcated hearing?
A bifurcated hearing, so a classic example would be where the issue of liability, so has there been a breach of contract, yes or no, is dealt with first, and then only if there has been a breach do you move on to phase two, which is the question of quantum, so what damages should be payable as a result.
Thank you. So Yosuke, in James's scenario where there's an argument about whether you are having a virtual hearing or not, but whether it's bifurcated or otherwise. Is that an issue for the integrity of the proceedings and the enforcement of any award that you get at the end?
Thanks, Craig. We looked into this as part of a different challenge on whether we're going to go ahead with a hearing or not. And actually, in terms of potential risks to awards being challenged as a result of holding a virtual hearing, we found that the predominant academic view was that it was in favor of online hearings as a sensible way to mitigate undue delay. And therefore, we'd expect this to be the starting point of most national courts in leading common law jurisdictions, at least, when considering challenges to awards arising from online hearings. And certainly pre-COVID authority coming out of Australia and the US suggests that a risk to a successful challenge on the basis of a hearing that was held online, at least in terms of witness testimony, which was done through video conference, is relatively low. So in general, it's probably not a significant risk factor in terms of challenging awards. But obviously it will depend on the circumstances of each case, and you might have a situation where the technology fails and you may not be able to respond to an argument, etc., which may increase the risks.
I am now petrified because we're midway through a Zoom conference and somebody has referred to technology failing. So I'm now going to be sitting at the edge of my seat for the rest of our time in fear of that happening. David, can we come to you? Yosuke has just spoken about the some of the issues, and suggested there's not a major threat to be using technology in relation to arbitration, but it's clearly a change. It's clearly disturbing the market in some way. Have you seen any signs of the issues there are around arbitration and litigation at the moment leading to any uptick in ADR, whether that's mediation, expert determination, or anything else?
I think from a personal perspective, it's probably still a little bit early to say, but I think if we reflect on it, there probably are factors in play which will point to an increased use of ADR by parties, particularly structured mediation. where you have mediation in effect supervised and run by an experienced third-party mediator. And a couple of points just to make clear that they are often run effectively in parallel as opposed to an alternative to litigation or arbitration in an attempt to get an early resolution if at all possible. And where a mediation often works best, and I can see there being growing opportunities here, its sort of sweet spot is where you've got two parties who genuinely want to resolve the commercial dispute. So it's not a defendant who wants to resist paying for as long as possible. And they want to do so in a structured and formal way that helps them ensure they've been through a rigorous process of some nature, helps them justify to management and potentially to shareholders any concessions they make in resolving a dispute. But where they need to resolve a dispute in the least aggressive and in the least toxic process possible in order to maintain existing and valuable business relationships between the two of them, with a view of resolving the dispute and then putting that behind them and moving on with future business. And why I say I can see more opportunities emerging is a classic example would be claims that have to be resolved in relation to supply chain interruption, but between partners who really do desire to go forward and continue their long-term relationship. So I think those opportunities will continue to grow. That's, of course, not to neglect the point that the technological issues and the practical problems of COVID, of face-to-face meetings, will have an impact on what a mediation looks like and perhaps how effective it can be. But notwithstanding that, I think increased opportunities.
Thank you, David. Tagaya-san, David mentioned supply chains in his answer. I'd be very interested to hear your thoughts on supply chain issues, and if you are able to, but I don't want you to breach any sort of confidentiality, so I understand if you can't say anything. One of the questions we had come in relates to how successful people have been in an attempt to renegotiate contractual terms. And so if that has been part of what you have seen in your supply chain dealings, I'd be interested to hear anything you might have to say.
Thank you, Craig. Yeah, happy to share with you our experience. So as we have already seen, escaping from the existing contract is not straightforward process. Claiming force majeure is not easy process. So what we have done in the past 6 months or so is basically to re-examine all possible mechanisms available in the existing contract that energy companies like ourselves can utilize. For example, reduced energy demand may result in increase in the latter half of the year, at least in some countries. In which case, can we allocate the procurement of fuel in the latter half or second half of this year, or even push back to the next year? In some of our existing contracts, that kind of mechanism, flexibility mechanism is available. So what we did over the last 6 months or so is to re-examine all possible mitigation mechanisms, bearing in mind that claiming force majeure and being released from the obligation is not an easy process. The government measures are becoming blurry. Government doesn't impose outright ban of the economic activities, rather like what we experienced in Japan. Government announces something soft, like please voluntarily lower the economic activities, in which case it's not clear to us whether we can escape from the contractual obligations. So instead of trying to escape from the existing contract, we are trying to utilize as much as possible the flexibility mechanisms already available to us. We are continuing this effort. We, of course, carefully study what is available from insurance and all other possible mitigation measures. But and also we are trying to get further flexibility in our contract going forward. So such a kind of effort, maybe renegotiating, but also for I think forward-looking contract mechanisms, we are trying to put in place as much flexibility as possible.
Thank you. Yosuke, putting in place as much flexibility as possible. Is that the best way for companies to try and protect themselves? Is there anything else that people should be thinking about?
Thanks, Craig. And I think that is the main key point. And some of the other things that I'm going to talk about now lends towards increased flexibility. So I think there's 3 areas that you can be taking proactive steps in, which will increase the flexibility and mitigate potential supply chain issues in the future. And obviously the first sign, first is being on the lookout for signs of financial distress with your counterparties. And the second is obtaining accurate intel on the supply chain. And last but not least is contingency planning. So to start with, the earlier you can get signs of financial distress in your counterparties, whether that's suppliers or customers, the more options you'll have to resolve issues and to negotiate and be flexible with that counterparty. And the typical early warning signs that you might see might be delayed payment or stretching of supply credit. There may be significant changes in the management of the counterparty, attempts to reopen commercial terms and contracts, or particularly aggressive approach to commercial terms. So once you start seeing these, it's an opportunity to have a conversation with the other party to see what can be done. Turning to the second point, it's important to continue to engage with customers and suppliers to get an early insight into their changing circumstances. So, once things go wrong, it can be difficult to get accurate information from that counterparty. So it's important to have good quality contact at your counterparty and to keep that line of communication open. And, as soon as problems seem to be on the horizon, continue to talk with them, see what they're saying, and they may reveal things that they're not aware of themselves in the information that they're giving you, which may indicate potential issues in the future. And thirdly, in terms of contingency planning, obviously you need to think about what you might want to do in the worst case scenario when the other party might fail. And this will obviously inform you of any knock-on impact on your customers and your ability to meet sort of downstream contractual obligations. You can also assess the importance of any particular customer or supplier to your business and how far you might be prepared to reach a commercial compromise and help the supplier out from avoiding a failure. And finally, just the contingency plan will allow you to consider whether you might want to acquire certain assets or bring certain production in-house in the event that a particular supplier may be in financial difficulties.
Which picks up, I think, very nicely. And one of the questions which we'd had, have companies set up financing for suppliers in distress? And which I think the answer is yes. Yes, some companies have. James, we've been focused so far really on commercial disputes in straightforward, contractual sense. What about things from a sort of compliance or regulatory perspective? Is there an angle there that we've been missing so far in this chat?
I think there's definitely an angle, and there's scope for a number of compliance issues to arise in the supply chain context arising from the fallout from the pandemic. So a good example would be supplier relationships. I think the disruption that's being caused in supply chains is causing a number of companies to either want to or have to look at new supply and distribution arrangements. And businesses are often quite fairly not going to have the time or the capacity to carry out the usual vetting procedures for new suppliers, which they would do. But of course, as soon as you have to start cutting corners in respects like that, you open yourself up to a broad range of risks, including bribery and corruption, anti-money laundering, environmental, health and safety, even human rights. So I think legal and compliance teams, although they may well be coming under increasing pressure from business teams to minimize the due diligence requirements when onboarding suppliers, should really try to hold the line. And although a degree of commercial pragmatism is not only understandable but likely to be necessary, try and ensure that due diligence is conducted as fully as possible, and as an absolute minimum, ensure that relevant checks are done to understand the nature of the supplier's business, the scope of the services being provided, and how that supplier's supply chain relates to their own business. And I think a particular sort of warning sign would be circumstances where you have a supplier or a service company that's suggesting that it's able to carry on its operation in circumstances where no one else can, or none of its competitors can. And that may well suggest that that supplier is either making false claims or it's engaging in some form of misconduct to ensure continuity of its operations, whether that might be breaching COVID containment rules or even going as far as bribing officials. The only other point I'd mention quickly is the potential for fraud in the supply chain. I think it's fair to say that cross-border supply chains are inherently susceptible to fraud, and that's true irrespective of the pandemic situation that we're in now. But the financial pressure that parties to supply chains are facing, restrictions on border controls, are all likely to serve to heighten that risk environment. I think a particular problem that some companies might be facing is that although lockdown measures are starting to ease in some countries, in a number of instances, companies are still having to work remotely, and that can make it difficult to ensure that usual standards of monitoring supply chains are in place. So I suppose, to give a simple example, it might not be possible to verify physical receipt of goods. So I think companies need to try and proactively identify any vulnerabilities that they have as a result of measures that have had to be taken because of the pandemic, and insofar as possible, try and ensure that they're mitigated and that usual procedures can be implied. But yeah, there's certainly a number of potential problems lurking.
David, from your perspective, is there anything to add to that? I mean, James used a number of very concerning words. I noted some of them down: fraud, bribery, corruption, pandemic, border controls, all things which sound tremendously concerning from a business perspective, but finish with a reference to mitigating. Anything else that you can add to what one can do to try and mitigate these risks?
Well, I agree with what James said, and of course these problems present themselves in different ways. So it's not just your new business partners and your onboarding of suppliers. It's also it will also present itself in relation to something else we're going to see, which is manufacturers looking perhaps outside of China to establish or acquire different manufacturing bases, alternative manufacturing bases. And so when you're acquiring businesses in high risk corruption territories, then that presents a very big challenge. And that challenge and the risks get more and more serious with every passing year. We can see that in terms of headlines of what happens when it goes wrong. Essentially, the most important thing for the company in that situation is there needs to be a real willingness to look hard at the business risk in that jurisdiction, then to take smart and targeted steps at reducing those risks that are relevant to its business and the target that it's acquiring. And that means some hard thinking, and that means some real serious internal budget. And not every company has got there yet. In short, in terms of steps you can take, there are 3 phases where you can exercise some control. Obviously, there's the pre-deal phase, and that's essentially the due diligence. Not always possible to do as much due diligence as you will like, but if the due diligence gives you the opportunity to identify any red flags in these companies that you're buying into, then that's something that you need to deal with there and then. That might be a substantive concern, maybe over a particular agent that's being used, or a particular business partner or customer, public customer and the like, or it might be a more process concern, a sort of a relative lack of a mature back office control type policy that causes you a bit of worry in relation to the risk you're taking on. Obviously, at that stage, do what you can to find out more, ask questions of the sellers and their lawyers, evaluate the risks with your lawyers. And if you decide to sort of park it, remedy it post-acquisition, document those decisions and the reasons you're taking them. That will be very useful if you ever then get subsequently into trouble. The second phase is in the deal itself. And I go back to what I said earlier on today. You can put in all sorts of representations and warranties that the seller has to give to you. Make sure those representations and warranties about adherence and compliance with the law go forward a number of years post-acquisition, if you're retaining some of the existing management who are in effect the sellers. And then the third phase, and this is where it's always the biggest takeaway, the third phase is post-acquisition. And it's just a commercial reality that deal teams are motivated by getting deals done, and then they move on to their next target. And there is nowhere near the same focus as there should be on post-acquisition integration. That needs generally more of a focus. It's good to set something with a timeline. So a sort of a first 100 days, this is what we're going to do. And that will be following up on specific red flags that may have emerged during the due diligence process. And it may be as well just looking around at processes generally. And a third thing that can be done, a lot of Japanese companies with many overseas subsidiaries have a financial back office audit going around all their overseas subsidiaries on a 2 or 3 year program. If you acquire a new company in a high risk jurisdiction, make sure you put them at the top, not the bottom of that queue. Make sure you get to see them as soon as you can. So they're the sorts of steps I would recommend be taken.
Thank you, David. Seki-san, Tagaya-san, I'll come to both of you. I'll ask you to be quite brief. I'm conscious of the time. Perhaps Seki-san first, because it looks as if you're dialed in from home. And David has gone through the red flags and the things we need to be concerned about. We are moving into a world, or have moved into a world, where so much is now being done by instant messaging, by WhatsApp. We're all Zooming and Microsoft Teaming, and we've moved away from sitting in the office on a telephone, sitting next door to somebody else who can hear what all's going on. I'd be interested to know what your take on it is, and whether there are any changes that you have seen to the approach that needs to be taken internally.
Yeah, sure. Thank you, Greg. So since the beginning of this incident, Amgen has been consistently taking a very cautious approach by putting our first priority on the safety of our own staff, and also the safety of our customers, who are basically the healthcare professionals in the fight against the COVID-19 on that front. So one of the example was that we are a fast runner who made a decision for all employees, including a sales team facing the customers on the front, to work from home. I think late in February. So that's why all Amgen employees have been working from for almost 4 months. And so basically there's no issue in terms of the business operation. However, in terms of our responsibility, legal team responsibilities are how we could execute a contract remotely by breaking through the CHOP or Hanko culture in Japan was a big challenge we had to address as quickly as possible. So as a result of the internal discussion, which was, as you can imagine, very intensive, we rolled out DocuSign, which is one of the e-signature technology available on the market for signing of the contracts right after Golden Week in May. So yeah, obviously digitalization has been the key priority of our legal team since I joined the company. And so in fact, we were going to launch that technology sometime this year, but this virus, COVID-19, obviously pushed us to early roll out that technology.
Sorry, Tagaya-san, before we come to you, just a second. You talk about rolling out the DocuSign. How was it received? Did it go down well internally? Were people glad to have it?
Yes, actually, in particular, our business team look forward to rolling out the DocuSign because if we launch that technology, they don't have to go to the office only because of the signing a contract, the signing document, or getting a Hanko. And so that's why implementation of the DocuSign is obviously making a significant contribution to efficiency of our business operation. So no issue and no challenge, and I believe they're very happy to use that.
And Tagaya-san, a similar experience for you or something very different?
Yeah, I completely agree to what Seki-san said. We also moved into virtual approval, electronic signing kind of systems. So efficiency has been the key for the last few months, making everything available in a remote working situation was the key in our company too. The only thing I would like to add from the legal and compliance officer's perspective is not lower the guard. Traditionally and pre-pandemic, we have this good old days type, paperwork, sign off from the GC, sign off approval from the boss when it comes to I think counterparty due diligence, whether this is the right person to interact with. We had to sign a number of paperwork. Although we moved into remote working situation, and we have every temptation to skip all those, bureaucracy within the company, but the paperwork has some positive effect, that slowed down things and to rethink whether this is a right person to interact with. So we actually increased the frequency of compliance training, of course, on a video basis, anti-bribery, FCPA risks everywhere. where we have activities in emerging countries. So other issues such as human rights, we haven't lowered the guard. We still keep those internal procedures, approval process in place.
Thank you, Tagaya-san. Yosuke, Tagaya-san spoke about keeping the internal processes in place. Seki-san began by explaining how very cautious we are as an organization. Is there an exposure? Is there a risk in all this agile working and new technology that we're embracing?
Thanks, Craig. I think we're seeing usage of more informal lines of communication when people are agile working. So this may be in the form of Skype messaging or Teams chat or even WhatsApp, for example. And this can increase risk because these are relatively casual modes of conversation. And you may feel more comfortable speaking more freely on an instant messaging service compared to emails, for example. So it's not uncommon to see potentially inappropriate comments on messaging services, which you wouldn't have otherwise sent in an email or a letter, for example, and that can create some risk. You're also potentially at the risk of disclosing confidential information compared to more formal communications. Now, another risk is the tendency to use abbreviations and emojis, for example, which can lead to increased risk of misinterpretation by the other side and arguments over what you actually meant. And we actually had a client who, where the counterparty said on WhatsApp, that's it, I'm out. And the client reasonably took the position that they wanted to terminate the contract. But actually, it later turned out that they claimed that wasn't the case, and an argument arose as to exactly what was meant by that message. So, that it perhaps increases a risk of disputes arising. And another point is, some of these messaging services, especially WhatsApp, tend to exist outside of the company's control. And therefore, it's very difficult for the company to monitor and have that on the company's records. And this can create certain risks, both from compliance and also from litigation or investigation perspectives. So the company potentially loses the day-to-day oversight of the employee's conduct. And there's also an issue whereby you may not be able to access those communications as evidence if you need that in a litigation or investigation context. So these days, many companies are allowing employees to use their personal smartphones to access work emails and conduct business on their personal devices. And it's relatively okay if they're still at the company, but once they leave, you're highly unlikely to get consent from them to image their personal phone. So that's another risk to bear in mind.
The comment about people not understanding the abbreviations reminds me that very famously David Cameron, when Prime Minister in the UK, received a sad message from someone, and he responded LOL, thinking it meant lots of love rather than laugh out loud, which caused some consternation with the person who received his giggling message in response to their sad comment. I'm very conscious of the time, and I'd like to just finish by doing a sort of general wrap up and going around the panel if I can, and asking everyone for a parting thought really at any of the aspects that we've been talking about. Perhaps we take as the key question whether the changes from COVID-19 and all that's happened are going to be long-lasting. I mean, is this changing the way that we work and the way that disputes are taken for the rest of time, or is this merely a passing thing? James, let me start with you.
Thanks, Craig. I think perhaps if I can say yes and no. So I think in terms of the yes, I'm afraid it is, isn't it? I think in terms of the disputes that we'll see, I think I'd agree with what David said earlier, that we'll probably enter into a cycle, and we'll be seeing disputes which, whilst coming out of a novel circumstance, will engage fairly typical legal issues and provisions, albeit potentially in a novel way. So in that sense, it's perhaps more of the same, although slightly different. Where I think we will see the potential for a longer lasting change is in the way that companies are doing business. I think we will see increased working from home, increased agile working, and with it, increased use of technology, whether it's for sessions like this or whether it's potentially in the hearing context that we discussed earlier. So I do think there will be some longer running changes that we'll have to engage with.
I'll give the final words to Seki-san, Tagai-san. So David, do you want to pick that one up? Closing thoughts?
I think I'm on the yes side. I think it has already profoundly affected businesses, and obviously there's no going back to how things were before. The thing I reflect on most of all is that those businesses who are facing real challenges and will have to restructure, whether it's in terms of different supply or different manufacturing options, I'd encourage them to think now is an opportunity, notwithstanding the difficulties, to invest in upgrading their compliance program in order to head off the risks that they could otherwise face with that restructuring.
Thank you. And then finishing off from HSF, Yosuke.
Thanks, Craig. I think I'll just briefly touch on the use of virtual hearings and arbitrations. Now, obviously, the pandemic has potentially accelerated the adoption of technology and use of things like Zoom for virtual hearings, but ultimately, many of our clients have disputes which are huge value, and in that sense, they feel that they should be entitled to a in-person hearing where everyone's in the same room. So there's obviously benefit in the virtual system, and being able to do so, you can save costs on parties traveling, etc. But at the same time, there may still be preference for people to have in-person hearings once this pandemic's over. So we'll see how much of the technological adoption remains once the restrictions are lifted.
So the consensus from private practice seems to be very definitely yes, things have changed forever. Seki-san, what about looking at life from in-house? Do you agree, or do you think this is all a bit more temporary?
Well, yeah, I was wondering how I can interrupt what forever means, because yeah, obviously COVID-19 has been and also will be significantly changing the various things. Yeah, of course, working from home is one of the typical examples, but I would anticipate that at some point in the near future, some people tend to go back to the conventional normal. For instance, going back to the office and getting together after the walking. So that's why I think a real challenge or real issue in front of us might be how we can integrate both new way of working and also the phase-2 engagement or communication in each and every aspect, not legal, but also business and our daily life or any other aspect. So that's actually the question in front of myself.
So, and Tagai-san, we began Seki-san's answer with the with some philosophy as to what forever means. It's a high bar for you to reach. But your thoughts?
Well, from my perspective, I think I am inclined to say yes. I think the cycle of this kind of thing happening is even becoming more frequent. Looking back, we had SARS, we had bird flu, swine flu, MERS, and this is of course one of the biggest. But I wouldn't be surprised the second wave may come immediately, and next year new virus was found. So we somehow have to cope with this kind of unprecedented situation for an extended period. That's my current take. My company is making every effort to increase agility, flexibility. Energy is a long-term business, so we have a number of 20-year contracts, and 20 years sounds like such a long time, but somehow we have to survive. So increase agility, increase flexibility, utilizing insurance, hedging, mitigate, and basically protect your company by yourself. That's what we have in mind.
Tagaya-san, I have been married for 20 years. I can assure you it's a very long time. I think I will draw proceedings to a close there. I want to say thank you to Legal 500 for organising the event. Thank you, James. Thank you to the HSF team, to James, David, Yosuke. Thank you to everyone who has sent in questions, much appreciated. But more than to anyone else, a very big thank you to Seki-san and to Tagaya-san for joining us on the video today. Thank you very much. James, I'm not sure if there's any sign off that you wish to give from the Legal 500.
I'd echo your thanks, and thanks, of course, to you, Craig, for moderating it and emceeing it expertly. I guess the only other thing to say is a video of this webinar will be on the website. We'll also have interviews with other GCs that we'll be conducting shortly. So if anyone wants to hear a wider selection of GC perspectives on the disputes market, you can find them on our website. But thanks to everyone for a wonderful webinar.